Good evening, everyone. We are now going to be calling to order the June 11th, 2024 meeting of the Milford Zoning Board of Appeals. Please stand for the Pledge of Allegiance. Thank you. And now the roll call, please.
Mr. Dubois. Gary. Sorry. Mr. Dubois.
Here.
Mr. Anik. Is he? There you are. Okay.
Here.
Couldn't hear you. Sorry. Ms. Hirsch.
Here.
Mr. King.
Here.
Mr. Montano.
Here.
Mr. Soda.
Here.
Mr. Wolf.
Here.
And Chairwoman Ferrante.
Here. Also present tonight, Stephen Harris, our Zoning Enforcement Officer, and Meg Green, our Recording Secretary. Before we begin, just a couple of notes. If you are here for 624, 626 Gulf Street, that has been tabled until the August meeting, so that will not be heard tonight. And also for 94 Edgewater Place, Mr. Montano will be recusing himself. Ms. Hirsch, will you please vote in his place?
Happy to, Madam Chair.
Wonderful, thank you. Okay, and Mr. Montano, we will begin with the first item.
Madam Chair, 3 Lawrence Court, MBP 28/579/2 R5. Thomas Lynch, Esquire, for Teresa Kowaleski and Scott Digris, owners. Bearing Section 3.1.4.1, east side yard setback to 2.1, where 5 feet, west side yard setback to 7.6, where 10 feet required. Bearing Section 4.1.4, east rear deck projection to 3.7, where 4 feet permitted. West rear deck projection to 1.5, where 8 feet permitted. West house stairs to 3.5, where 8 permitted, all to construct a front addition with side stairs and a rear deck. Survey by Land Surveying Services, LLC, 03/29/24. Thank you.
Good evening, Madam Chair, I should say. Sorry, Ms. Chair. Members of the board, just for the record, my name is Thomas Lynch. I'm an attorney with the law firm of Lynch, Trimbicki, and Boynton. My office is located here in Milford at 63 Cherry Street, and I'm back here tonight. I have 2 matters before you tonight that were both continued from last month's meeting. If some of the board members weren't here, there were some procedural hiccups that arose during our presentation, so I'm going to be brief. Most of the comments relative to this application I had made last month, but I'll summarize the position. So I'm here with Teresa Kowaleski and Scott Nigris, my clients. They're the owners of the property at 3 Lawrence Court. They've owned this property for many years, and we've brought this application to you to allow for a rear deck to be constructed on the sound side of the building, and for a new addition in the front, which we talked about last month, is going to contain an elevator. Both of my clients have physical disabilities, along with Teresa's mother, so that the design here is to put an addition on the front portion of the property that's within the front yard setback, to allow for some additional living space, but primarily the elevator that's going to go in there. So, as I said, the clients have owned the property since 2001. It's currently an 1,880 square foot raised level house. After the combination of storms Irene and Sandy back in 2011 and 2012, the house was raised. My clients got the necessary permits to elevate the house to the BE zone standards. And in doing so at that time, and we have pictures, I assume they're still part of the website presentation. We had them from last month, but if you recall, I showed you the pictures of the property at the time that the house was raised. There was a detached garage that was in the front portion of the property that actually infringed upon the front yard setback. So when the house was raised, that garage was taken down, and now with the new addition that's going to be coming to the front of the house, again, there's no necessity for seeking front yard setbacks, but because of the fact that it does extend the nonconformity of the two existing side yards, that necessitates this application to you. As well, the plans that we brought with us last month showed the access stairway on the right-hand side of the house. Unfortunately, that didn't make it onto the survey, so that we revised the survey showing the new access stairs on the side of the house to replace the existing stairs on the front. So in other words, the house is currently serviced by a very elevated stairway going from ground level up to the first level. That's going to be eliminated, and now there'll be a side stairway on the front side of the house where the addition is. To the rear, and again, between last month and this month, my clients had been contemplating putting a deck on the house. They spoke to Stephen, so the plans were revised to show a conforming, again, rear yard setback deck. It does not infringe upon the FEMA requirement of having a special permit application because it's less than 25 feet from the mean high tide line. But again, because the deck extends out with the current non-conforming side yard setbacks and the projection necessary for the stairs, that is what led to the application for that variance. So that summarizes, where we were last month. I'm happy to answer any questions that you might have. I know, Bill, I think at the end of last month's hearing, you were looking for the plans to show the area where the garage was, and I think that they are shown in a dotted line area on the survey. So that garage that had been basically in the area where the new addition is proposed, that was removed back in 2012. So again, happy to answer any questions you may have.
So Mr. Lynch, for clarification, this new plan is front yard zoning compliant, whereas the pre-existing, it was infringing into the front yard setback?
Not the prior application that we had last month.
No,
the house before was
correct.
Correct. There was a nonconformity with the garage in the area where it was.
And this is only seeking side yard setback and projection, side yard projection variances to extend along the existing footprint, front and back.
And the existing nonconformities are not increased at all. Basically, the addition is going to follow the same line of the house, and the deck is going to do the same to the rear.
With no front or rear yard infringement?
Correct.
Correct. Okay, great. Any other questions for Mr. Lynch?
Attorney Lynch, did you say you added the deck this month?
I didn't
Was
hear
the deck on last month's plan?
No, that was added. Yep.
So why isn't the deck just in line with the house? And then move the landing forward so just the landing is closer to the property line so that the deck...
I believe the deck is in line with the house. There was some discussion about having...
No, they brought the deck all the way out to the landing on the plan I have. Yeah, it's up there too.
So if you move the deck, if you made the deck a foot shorter...
No, you have to make the deck 4 feet shorter and then extend the landing, so the landing would just be...
But that would still necessitate the projection requirement.
You'd still need the variance, but,
Right.
But it wouldn't go
It
all
wouldn't
the
be
way
as
to the
bad.
back of the deck.
yeah. You see what I'm saying?
I'm honestly not following you.
If you come up here, I'll show you.
Well, I'm looking at the screen. So you're talking about the deck, and there's the stairs going up to the deck.
Okay, so where the landing is right now,
Yeah.
push the landing forward, and then cut that part of the deck off and keep the deck in line with the house. In other words, if you just cut that 4 feet off the deck, and then slid the landing
And
forward.
put the landing in? Yeah, is there...
Yeah, no, you extend the landing forward, so you could get on the deck. Extend it towards the water.
Excuse me, we need everyone speaking to speak into a microphone for the record.
Speak through me. That's okay. So what's your question?
You know what I mean, right? So you lose this, and the landing will come to here.
Madam Chair,
Yeah.
Madam Chair, this
Yeah.
conversation
all
should
this
be on
would
the
be
record.
Please speak into the microphone.
The explanation was it was designed that way to accommodate a wheelchair?
Well, you'd still be able to accommodate a wheelchair. You could bring it 4 or 5 feet onto the deck, and then you still have your turn. 5 feet is all you need for handicap access to make a turn.
So what would that eliminate then? In terms of the variances? 4x5.
Was that a question for me, or?
Bill, did you
to
draw
Stephen.
it out?
Yeah, I drew it out.
In other words, if the landing is eliminated, you still have to have the stairs within the projection.
Right, but
Yes.
But it wouldn't have to go all the way to the back of the deck. Correct,
Yeah.
Mr. Soto?
yes, it would be a little less of a variance you need. I mean, you still need the variance, but the deck wouldn't be so obstructive, you know?
Well, I believe the landing is where the door is.
That landing might eliminate the deck, but it's still part of it.
Mr. Lynch, maybe if you took a look at what Mr. Soto drew up.
You guys say, wait.
His suggestion is to
Yeah, I'm looking
put and then eliminate this corner so that the deck comes here and it just projects out here and the projection doesn't carry all the way to the back of the deck.
So it would eliminate the projection for just the distance from there to there.
Correct, this back corner.
Yeah, all right.
Do you want to show that?
No, I get it.
They would still have full access to the deck the same
So
way.
can the request for the variance be just amended for the purposes of tonight, or do you have to have it redesigned? Let me show Stephen.
No, we can't amend the variance on the fly. You can,
But we could condition an approval. Mr. Soto, that deck is 11 feet deep. Are you proposing 5 feet for the landing and then cut off the remaining 6 feet? 6 by 4?
That's a good way to describe it. 6 by 5 is on the east side.
What's that? It's 6 by 4.
West side.
It's the west side. West rear. Take the 6 by 4 corner off the deck. Okay, so Attorney Lynch, as you explain it, what we're saying is it would be
Now I
5
got it.
feet here out of the 11, so it would be the remaining 6 feet by 4 feet.
I think
Is
Stephen
what would come
scaled
out.
it, so he actually has the measurements.
Okay, great.
Okay. All right, thanks. Can I have just a moment, Madam Chair? All right, so this is that. So what they're saying is, instead of having
this go all the way to the back. You have your landing go roughly right here, so you can get on the deck, but you don't need to have this jog.
So, in other words, we're not going with the deck all the way over here.
Exactly.
This is what I'm going to do, thank you.
Are there any other questions for Attorney Lynch?
Yep,
And then it's going to go down here.
that's going to be gone. That part of the deck will be gone.
Okay, while they're consulting.
Yeah.
To begin with.
Okay.
Okay. Is there anyone speaking in favor of this application?
Okay, we're good.
Is there anyone opposed to this application? Mr. Lynch?
Can I just note for the record, I did have the opportunity to go over this with Teresa and Scott, and that is actually what they originally were thinking of doing, so they have absolutely no objection to what you proposed. Thanks.
Okay, great.
Okay.
Okay, wonderful. Any other questions for Attorney Lynch? No? Okay, and nobody speaking in favor and nobody opposed. This hearing is closed. And we need a motion.
I move to approve as presented with the following modification to the map presented at the hearing, removing the west corner of the deck. The petition of Thomas Lynch Esquire for Teresa Kovaleski and Scott Digris, owners, to vary section 3.1.4.1, east side yard setback to 2.1 feet where 5 feet required, west side setback to 7.6 feet where 10 feet required, vary section 4.1.4, east rear deck projection to 3.7 feet where 4 feet permitted, west rear deck projection to 1.5 feet where 8 feet permitted, west house stairs to 3.5 feet where 8 feet permitted, all to construct a front addition with side stairs and a rear deck, surveyed by Land Surveying Services, LLC, 3/29/24.
Madam Chair, that would be as conditioned by the map submitted by the applicant at the hearing.
Yes, I believe Mr. Soto said that in the beginning, but for the record, the motion is
Yeah.
conditioned.
Condition with the map presented at the hearing, removing the west corner of the deck,
Okay,
west rear corner of the deck.
great. Do we have a second?
Second.
Wonderful. And discussion. There are certainly improvements on this plan, eliminating some
Madam
nonconformities.
Chair, has the hearing been closed?
Yes. Eliminating the nonconformities in the front, not asking for setback variances in the front yard and rear yard. It is a narrow lot, 30 feet where 50 feet is minimum, and this application is just continuing the existing lines and footprints relative to the side yard. So with the modification previously discussed, I'm okay with this.
I'm okay with it.
All right, then we will have a vote. Mr. King?
With the motion.
Mr. Wolf?
With the motion.
Mr. Soto?
With the motion.
Mr. Montano?
With the motion.
I'm with the motion. The motion passes.
All right, thanks so much.
You're welcome. Item number 2, Mr. Montano.
574 Milford Point Road, MVP 15/51/5A, R 12.5, Thomas Lynch, Esquire, for Benjamin and Patricia Kovacs, owners, variance section 4.1.1.4, to allow accessory building of 952 square feet where 796 square feet are permitted, to construct detached garage, surveyed by Stewart Somers Company, LLC, 04/02/24.
Again, thank you, Madam Chair and members of the board. Again, for the record, Thomas Lynch. On this file, I'm here with my clients, Ben and Patricia Kovacs. And again, this file was, or this application was carried over from last month because there had been an error in the advertising of the notice. And even though Stephen was kind enough to say, well, we could have amended it right then and there. I felt that it was better to have it go over for a month so that proper notice went out, and we all knew the exact size of the permitted garage as it relates to the size of the house. So again, I started in my presentation to you that the clients have owned the house since 2016. They have a 3-bedroom, 2,000 square foot expanded ranch with a porch on the property. It's in the R12-5 zone. It's a pretty large parcel of land compared for what's required over the zone. The parcel is actually double the size required by the zoning regulations. So it is a large parcel of land that I feel is sufficient to clearly accommodate this size of a garage. My clients had brought an application to you back in 2022 with a larger garage. The size of that garage that they were proposing was 1,064 square feet. We've cut it back down now to 952. But again, the regulations call for a maximum size of the garage based on the, the footprint of the existing house. So that we are before you with this application. It's a 3-bay garage. It's to accommodate the cars and equipment that my client has on site. He does his own work on his property. In conjunction with that, if any of the members had gone out and driven by the property, you'll see that at his own expense, he had all of the sidewalks replaced around the circumference of his property. So he's really taking steps to improve the property, and that's a great expense that he's undertaken, but he felt that it was something that he wanted to do, both for the aesthetics for him to enjoy, but also it's a help to the city. He was not under any notice from the city that the sidewalks were in disrepair. He was not put on notice of any sidewalk lien that was going to be imposed. His property was not part of any municipal project where the sidewalks were going to be replaced. So I'm just offering that to say that he's come before you, or is coming before you in good faith to try to improve his property. And I think that this is a reasonable request compared to the size of the property and the reduction in the size of the garage from the prior application. With that said, I'm happy to answer any questions that you may have. And my clients are both here as well.
Okay, thank you. Attorney Lynch, this is a reduction from the May 2022 application. However, in reviewing the minutes from that meeting, there was no real determination of hardship, and the board determined that other variations of this project could exist without variance requests. So in that respect, with regard to hardship, what has changed?
Nothing has changed specifically in terms of the hardship. What I am supplementing for the comments that my clients made on their own behalf when they came before you, without counsel, a lot of times people don't know what a hardship is, and they don't have a good answer to give to you. What I'm saying to you is, in this case, there's no hardship as it relates to the land itself, but the size of the parcel can be taken into consideration in terms of determining the reasonableness of the request. It's in harmony with the neighborhood. It's in harmony with the standards for the R12 zone. This is a parcel that's some 23,000 square feet in size in an R12 zone. So with those considerations, I believe, in conjunction with them reducing the size of the original request, which the board may very well have felt at 1,064 square feet, that was an exorbitant request. I'm saying to you that in light of all the facts relative to the property, this is a reasonable request, and I'm asking you to look at it in the light of it being a reasonable request.
Attorney Lynch, do you have any elevations for that garage? Is it a standard gable roof, or are you putting a...
No, a standard gable. He did not hire an architect, but it's just going to be a standard gable.
with like a 5 pitch or something on it?
Yeah.
Not so they're looking
Maximum 15 feet, the whole,
Not so they're looking to get a room above it or anything?
No, no
Because if
room
you put a
whatsoever.
12 pitch on it, and you put 4 gables on it, you could get, it would still meet the 15-foot requirement, but you'd have,
I can come to mind of 3 applications that I've brought before you where a condition has been made to the variance that no living space be allowed in this garage, and that would be agreeable to my
do you have a
clients.
problem if we limit the pitch to a 5 pitch on the roof?
No,
Okay.
it's really the floor area build that they're looking for, you know.
Attorney Lynch, this proposal is 34 feet wide by 28 feet deep. You can still get 34 feet wide, and you can go 23 feet deep and meet the zoning requirements and not need a variance. I'm also seeing an additional shed on the property, so why do, you can fit 3 cars in that garage if you make it shorter and zoning compliant, and there is extra storage on the property.
I think that I had made the comment at the last month's meeting that shed is going to be removed because the driveway to service the garage would actually be coming through a curb cut that he's established on Sunset Avenue. So
Okay.
that, Sarah, that's a great question, and the answer is that accessory structure is going to be removed.
Okay.
I can represent that, and if you want it to be, again, a further condition of an approval, I mean, I asked Ben that specific question again this morning. He said, no, I had a curb cut for the new sidewalks, and that's where the driveway would go to the garage. So that shed is going to be eliminated.
Okay. Any other questions for Attorney Lynch? Is there anyone speaking in favor of this application? Please come forward, state your name and address for the record.
No, that,
Sorry, I think, should we use this one over here?
yeah.
Some technical difficulties. Thank you for your patience.
Yeah, sit right here.
Yes, thank you.
Step right up. And the red light's on, so you're good.
Jeffrey Mastropetri, 13 Sunset Avenue. I'm in favor of the garage. Everything that Ben has done to his property has only brought my home value up, and everything he does looks great for the neighborhood. So,
Okay. Great, thank you.
yeah.
Is there anyone else speaking in favor? Is there anyone opposed to this application? Okay. Any other questions for Attorney Lynch? Okay, this hearing is closed. We need a motion.
I move to approve as presented the petition of, I move to approve as presented with the following modifications. The garage will be limited to a 5 pitch on the roof. The petition of Thomas Lynch Esquire for Benjamin and Patrick Kovacs, owner, to vary section 4.1.1.4 to allow accessory building of 952 square feet where 796 square feet permitted to construct detached garage, survey by Stewart Summers Company, LLC, 4224.
Second.
Okay. Do you want to add the condition of the removal of the shed?
Can I add? Okay, also the removal of the shed to add to that motion.
Okay. Discussion. It is a larger lot. It can support a larger structure. However, it is not zoning compliant, and there was no demonstration of hardship in 2022 and no demonstration of hardship tonight. Hardship is our standard, not reasonableness. Any other thoughts?
Well, I don't have a problem with it because by putting a 5 pitch on it, it's going to be lower, it's not going to stick out. And, 8-foot wall with a 5 pitch on it, it's going to be probably 15 feet to the top of it, not to the midpoint. So, and it's a big lot, I think it'll look good on the lot. And plus you're getting rid of the shed, which is closer to the road. And it's all behind the house, so I think it'll fit in nicely.
And we do have one neighbor support and no opposition. Any other thoughts? Okay, if we're ready for a vote. Mr. King,
With the motion.
Mr. Wolf,
I'm with the motion.
Mr. Soto,
With the motion.
Mr. Montano.
With the motion.
I'm against the motion. Motion passes. Thank you. Mr. Montano, item number 3. You are recusing. Yes, thank you very much. Excuse me. All right, we are on to 94 Edgewater Place. Mr. Montano is recusing himself, and Ms. Hirsch is stepping in to vote. And I will read this into the agenda myself. Sure, Ms. Hirsch, you can read it.
94 Edgewater Place, MBP 45-513-40, R12.5, appeal the decision of the zoning enforcement officer in accordance with the provisions of Section 9.2 regarding certificate of zoning compliance. Date certificate issued was 4/19/2024. Joel Green Esquire for Christopher McKenna Appellant, CPK Properties LLC, owner of 94 Edgewater.
Good evening, Madam Chair, members of the board, staff. My name is Joel Green. I practice law in Bridgeport, the law offices of Green and Gross, and it's my pleasure to appear before you this evening on behalf of the appealing party, Christopher McKenna. This is an appeal pursuant to Section 8-6 from a ruling by Mr. Harris as the zoning enforcement official approving a certificate of zoning compliance pertaining to 94 Edgewater Place. It is our position that the premises are not zoning compliant, and therefore a certificate of zoning compliance could not issue. Ironically, there is no question that the property is not zoning compliant. It doesn't meet your zoning regulations as to width and as to lot area, among other issues. By way of background and history, this property is an assemblage of what were a series of 10-foot strips that ran to the harbor from Edgewater Place. And they corresponded to building lots that were in the so-called upland area. So when zoning was established, these 10-foot lots existed. And they were used, they could be used, and they were used for access to the water, for docks, and for boating purposes and the like, and they have historically been used that way. The 4 parcels in question, the 4 strips of land that make up this parcel, have never had a house on them. So never in the history of these lots since zoning was adopted has there ever been a residential use on these properties, ever. So there can be no finding that this is a legally existing, non-conforming building lot. And once again, there's no question that it does not comply with the zoning regulations. In fact, the evidence, and I know we've put a lot of evidence in the record, and we've submitted quite a bit of material and records from other proceedings involving the Zoning Commission and involving an appeal to the Superior Court. And I note that counsel for the property owner has submitted a large volume of material, and yet this boils down to some very simple issues for this board. Now, the essential principles that govern this appeal are, first of all, that this board does not owe deference to any other board, body, commission, or the court. So what I mean by that is that this is, as we've stated in our appeal, this is what's known as a de novo review by this board. The only finding that this board must make is whether the use of that property at 94 Edgewater Place complies with the zoning regulations, whether it was a building lot. The fact that there is a house there is really a distraction at this point. The owner of the property proceeded with the construction at their peril. And so as a de novo appeal, once again, the only inquiry that this board has to make is whether it's zoning compliant. You are not bound. You do not owe deference to any finding by the zoning commission. And yes, everyone has conceded that there is a pending appeal. But this board, that's just a distraction, and that doesn't bind this board. There may have been findings made by the zoning commission on camera view. That does not bind this board in this appeal. So once again, the inquiry, quite simply, is whether it complies with the zoning regulations or not. All of these other things are really distractions and don't go to the jurisdiction of this board in reviewing the use. I don't know if the board has questions, but once again, there's no question that the parcel is only 40 feet wide. It's 4 10-foot strips. They're approximately 100 feet deep. Therefore, it does not meet lot area. It does not meet lot width. So we are asking this board to find, in the exercise of its jurisdiction, that a certificate of zoning compliance cannot issue because it is not zoning compliant. I don't know if you have questions for me, but that's really what this appeal boils down to.
Does anyone have questions for Mr. Green? Mr. King?
Mr. Green, how are you this evening?
I'm well, thank you.
Excellent. You keep saying that the property is not zoning compliant. What regulation are you saying that it doesn't comply with?
I believe that your lot width requirement is 50 feet for a building lot in the zone, and this is only 40 feet wide. And the lot area has got to be 10. And the lot area is less than the 10,000 feet required.
12,500.
I'm sorry, 12,500. I'm corrected.
It's a 12,500, it's an R12-5 zone, and the lot area is 4,000 square
Sir,
feet.
you need to
I
identify
apologize, and this is
yourself.
my client, Mr. McKenna, who is with me this evening, for the record.
Mr. Soto?
Those are the two regulations that
Yeah,
you're
for
signing?
purposes of this discussion, correct.
Okay,
And
thank you.
again, once again, the property has never been used previously for a residential use of any kind under the zoning regulations. I should also note that the use of the property for docks and for boating purposes, for boathouses and the like, were uses that were previously allowed as of right under the zoning regulations, and they were subsequently amended to provide that those uses were allowed pursuant to a special permit. So the lots may, as a legally existing non-conforming use, be used for a dock, for a boathouse, and for that sort of thing. But once again, there was never a residential use that existed at the time that the regulations were adopted, and we've identified the infirmities in the lot.
I have a question. Was there a zoning permit issued to build the house?
Yes.
So now you're coming to us after the house is built and they're looking for a compliance certificate, correct?
Well, yes and no. We are appealing that, and significantly, the house is built because the owner of the property elected to proceed with construction in the face of an appeal. And so, yes, that is correct. But as we identified in our supplemental response, the case law in Connecticut is clear that that an owner of property who proceeds with the development of their lot in the face of a pending appeal does so at their peril. I would also say, based on my experience, it is extremely difficult, if not impossible, to get a restraining order, because once again, the law recognizes that a party may proceed, but they do so at their peril.
Any other questions for Attorney Green? Yeah, go ahead.
Good evening, Council. Council, you indicated it's very difficult to obtain a restraining order to cease construction.
Correct.
Did your clients, though, apply for injunctive relief at all, or?
No, and I would also submit that there is no obligation on their part, and I just want to emphasize that I have on occasion been involved in cases that we felt presented a situation where irreparable harm would result, meaning, as this board may be aware, there are circumstances where injunctive relief may issue, but the burden is on the moving party to show that absolute irreparable harm will result from the proposed development. And even in cases where we felt that there was irreparable harm, the position of the court has consistently been, you don't have a problem, because if your appeal is sustained, once again, it is the owner who proceeds that does so at their peril and has the problem at that point. And there's a case actually famously in Weston that involved a house that was built, I believe it was 3 inches too high. And it went to the appellate court. The owner proceeded with the construction in the face of an appeal. And at the end of the day, the owner had to lower the roof and remove the roof from the house and lower it. That is the Morikawa decision, which you may have heard of. I'm sorry.
Excuse me, also, we actually did send a letter to the city to ask them to have the project stopped, and they did not. That was done by Mac's case.
That's correct.
Back in mid-February or so.
Thank you.
Okay, any other questions? Mr. Harris? Again, well, if there are no other questions for Attorney Green, then the mic is over to you.
Is it my turn now?
Yes.
Okay. Stephen Harris, zoning enforcement officer. I'll be brief. Just going to run down the procedural history, then my position and a conclusion. So, number one, on April 5th of 2022, the Planning and Zoning Board approved the coastal area site plan application to construct a single-family dwelling. On January 1, 2023, a zoning permit was issued to construct the house. An appeal of the issuance of the zoning permit was taken and heard by this board April 11th of 2023. On that date, the board upheld the decision to issue the zoning permit, meaning they found that this project was zoning compliant. On May 4th of 2023, the ZBA decision was appealed to Superior Court. To date, the court has not ruled on that appeal. On April 19th, 2024, a certificate of zoning compliance was issued to close out the file. On May 3rd, 2024, an appeal of the issuance of the CZZ was filed. So, my position is, this applicant has taken an appeal of the issuance of the certificate of zoning compliance. He presented the same arguments that he presented when he appealed the issuance of the zoning permit, and the board rejected those arguments. The as-built survey shows that this house is zoning compliant. If a project is zoning compliant, I mandate it to issue the certificate of zoning compliance. So I would respectfully ask this board to uphold the decision to issue the certificate of zoning compliance. I'll be happy to answer any questions.
So the house built that is receiving the certificate of zoning compliance is in accordance with the site plan application that was approved by the Planning and Zoning Board that then precipitated the building permit. So what is built is what was presented and approved.
Correct. After a project is built, everybody goes out and does their final. The building inspectors do a final inspection to see if it's building code compliant, and I go out to see if it's zoning compliant. If it's zoning compliant, then the permit holder gets a certificate of zoning compliance, which is the case here. And just to reiterate again, the appellant has not presented any evidence that this board hasn't already heard and rejected.
All right. Any other questions for Mr. Harris? Mr. King?
Good evening, Mr. Harris, how are you? They cited the lot width and the lot area were not zoning compliant, and is it because that this was approved, because it was approved by the the Planning and Zoning Board?
Way back when the project started, and this has nothing to do with the issuance of the CZZ, this parcel was made up of a number of original developer lots, which was then consolidated into a new lot, which is allowed under the regulations, even if it remains non-conforming. So you take smaller parcels, combine them together to get a more conforming parcel. That's permitted, expressly permitted under the regulations. That's what this applicant has done. That's what many other applicants have done. So this is a building lot. That's not the issue before this board, but it is, you can rest assured, this is a legal building lot.
And you issued the certificate of zoning compliance because it complied with zoning regulations, correct?
Yes, because the project complied with zoning.
Any other questions for Mr. Harris? Okay, is there anyone speaking in favor of this appeal? Is there anyone opposed to this appeal? Please step forward. Or actually, we're going to be using this microphone over here, if you would.
Madam Chair, would I get an opportunity to speak as the property owner's attorney at some point?
Yes, since this is already in motion, why don't we?
Thank you.
Yep. Okay, great, thank you. You're going to be reading this into the, we need you to speak into the microphone. Okay, so we have a statement and photos for the record, and you're going to be reading this into this. Okay, wonderful. Okay. All right. Yes, if you could take a seat over there and state your name and address for the record. Thank you.
My name is Deidre Arts. I am a lifelong resident of Milford. I reside now at 9 Nair Lane in Milford. I'd like to read a statement, and I am strongly, myself and my husband are strongly opposed to this appeal that is brought to you. I'm speaking on behalf of myself and my husband, Brenton Arts, who is also here in the gallery. We are owners of 104 Edgewater Place. We sit directly right next door to Mr. Montano's property. We are not across the street, we're not down the street, we're not in the vicinity of the neighborhood. We are right next door to Mr. Montano. We strongly oppose this appeal and convey the following information for your understanding. We purchased our property 21 years ago. It was an overgrown, littered mess of junk, debris, neighborhood trash, yard and tree clippings, old boat docks, liquor bottles, and beer cans. Edgewater Place had been an environment which drew the likes of teenagers that came down there to park and party. It was a very dark, scary, and secluded place. There was limited access. There were no harbor views to enjoy. There was no beautiful landscape or beautiful setting to wander through, nor a walkable level road surface to access and stroll. Immediately upon the purchase of our property, we decided to take on the financial burden and overwhelming task of cleaning up and revitalizing Edgewater Place. And we did so by hiring Brennan Construction Company in Shelton to construct a safe, right-of-way paper road. This is what the city owns it, and they consider it a paper road, which is owned by the city, but it's not maintained by them. So they have no financial interest in it. So it was our duty to be able to drive our vehicles on it. So we needed to maintain it, we need to clean it up, and we needed to gain back our property because the properties that were abutting it had encroached on this road. You could see in some of the photos that I sent to you, and a lot of them are when we had started the cleanup, but you can see there was a big long fence, so there was no access for anyone to even access one side of this particular road. So by doing so, by taking on this financial burden and this huge task, we provided a safe access for all the area neighbors, the ease and the complete right use to come from Wilbar Avenue, down Edgewater, all the way through to Harborview Avenue. This resulted in a more park-like setting. We planted gardens, we had lighted areas, and it gave everyone a clean, designated gravel road to safely walk on and enjoy at their leisure. Currently, Mr. Montano and ourselves share the cost in repairing and maintenance to this road. Again, this city right-of-way road, but the city does not maintain it. We ask nothing from the surrounding neighbors. We would also like to convey to you that we have not been impacted one bit by Mr. Montano's home. In fact, his ownership and his vision has beautified 94 Edgewater Place and the surrounding area. He's helped us help improve the area. On another note, we owners on Edgewater Place pay taxes on these lots just like any other property owner here in Milford. They're approved building lots and are taxed as such. This has been established and endorsed by your departments and your governing heads. We ask that you allow us the right and the privilege to enjoy and use our property no differently than any other Milford resident. The harassments, the aggravation, the ongoing appeals, and the constant unsubstantiated claims need to stop. Together, Mr. Montano and ourselves will continue to be committed to maintain and upkeep the area, our properties, and the road for all to enjoy. We kindly ask in return your continued support in allowing us and him to enjoy our properties in peace with no further interruptions or repercussions. We deserve the right to develop and live peacefully without the interference of others. I am aware that you have recently received photos that were taken this past May 2024, which show that Christopher McKenna, whom resides at 24 Rose Street, and who has spearheaded this crusade, does not have a view from his home. I have also just provided you with photos that date back to May of 2003, which also confirms that there were no harbor views from the McKenna's property that overlook 94 and our 104 Edgewater Place. I want to thank you all for giving me this opportunity to speak in favor of 94 Edgewater Place and to please put an end to these unsupported and frivolous claims against Mr. Montano. Thank you.
Thank you. Is there anyone else speaking in opposition to this appeal?
I am, Madam Chair.
Yes, Attorney Crusaden.
So, for the record, Kevin Crusaden, 3 Lafayette Street, here in Milford. I'm representing CPK Properties, LLC. I do have hard copies of the photos that I submitted electronically. I'm just going to submit to the board. These are the same photos I've given to Attorney Green and Mr. Harris. So since I started with the photos, the relevance of the photos, and it's our position that the photos show a zoning compliant structure on the property. It also is evidence of the location of the appellant's property in relation to Mr. Montano's, where they're diagonally apart from each other, 70 to 100 feet or so away from each other. The photos also show a house that was built in compliance with the approved site plan, which you've heard about tonight, which was approved by the Planning and Zoning Board. It is very simple, this issue. The Planning and Zoning Board approved a coastal site plan, determined that the property was zoning compliant, including it being considered a building lot. That decision was not appealed. A zoning permit was issued based on that site plan approval. The structure was then built in accordance with the zoning permit and the site plan approval. There was an inspection after the structure was completed. Mr. Harris inspected it. It's inspected by the building department, and then the certificate of zoning compliance and the certificate of occupancy have been issued. So the claim that it's not a legal building lot was settled many years ago, actually, but more recently when the Planning and Zoning Board decided that it was zoning compliant. And historically in Milford, there's regulations that exist in the way Milford Department of Permitting and Land Use and the city planner and also Mr. Harris and his predecessors look at these old lots, because Milford has a lot of these old lots. Just by way of reference, as an example, Mr. McKenna's property is comprised of 4 different lots, and it's also not zoning compliant as far as the width of it. That's just an example because it's all over the city. If you weren't allowed to consolidate a lot of these smaller lots, then you would not have a lot of the building lots that we have. So if you consolidate smaller lots, whether they're 10 feet or 15 feet or whatever the original purpose was, and you consolidate lots to a point where you can build a structure that meets the zoning setback requirements, lot coverage requirements, and is otherwise zoning compliant other than being a building lot, other than being meeting the square footage or area of the zone that it's in or the width, you're allowed to build a house on that lot. This is a single-family residential zone. It's a single-family house across the street from other single-family houses. This is not some non-conforming use that we're talking about here. And I do also want to point out respectfully that the previous appeal that this board heard was also of an issuance of a certificate of zoning compliance. They tried to walk back that claim during the appeal that's sitting in front of Judge Welch in Derby Court. We're on a break because there's supplemental briefs related to that trial, that the original appeal was of the zoning permit. That's not what the appeal stated that it was, and that's in the record, that original appeal. That was also of a certificate of zoning compliance. So this is the second appeal for a certificate of zoning compliance that this board is hearing. The board unanimously denied the first appeal, and rightfully so, because it is, Mr. McKenna's allowed to bring the appeal. I understand that. But this board has already made this decision. There are no new arguments presented. It's not like we heard tonight that other than whether it's a building lot or not, which it's a building lot, that there's anything else that was not zoning compliant with the structure that was approved by the Planning and Zoning Board and has been built. What you should be hearing, if there was an issue with the certificate of zoning compliance, is that the setbacks aren't met, or that the house is 45 feet high instead of 35 feet high or 25 feet high or whatever it is. There's none of that evidence presented. It's just a retread of the same previous incorrect argument, and that's not how Milford handles these old lots. So the vast majority of the exhibits that I submitted the other day are already part of the first appeal. There's some photographs which you have here tonight. There's the certificate of zoning compliance. There's the as-built survey. And I'm available to answer any questions that you might have, and we ask that you deny this appeal tonight. Thank you.
Any questions for Attorney Crusaden? Okay. Any questions for anyone before we close the hearing? Yes. Go ahead.
Attorney Kersaden and the property owner are asking this board to do exactly what you cannot do. This, again, is a de novo review by this board. You do not, the zoning commission doesn't tell this board what to do, nor do you owe the zoning commission any deference in your review. The zoning official does not tell this board what to do, nor do you owe the zoning official any deference in making this decision. This is, and I know I've said it 4 times, but apparently I have to say it a 5th time, this is a de novo review. That means you begin at 0 in this appeal in reviewing this, this property and the proposed project. The comment, that's how Milford deals with these non-conforming lots, is simply not true. Your regulations at 6.4.1 deal with non-conforming lots, and it does provide circumstances in which non-conforming properties can become building lots under certain circumstances. But the problem here is that one of the findings that the board must make in satisfying the zoning regulation is that the present owner or his predecessors in title did not illegally create this non-conforming lot, and that the lot was of legal size when it was created as a lot. Well, first of all, this never was a lot. It never met the standards of your zoning regulations. But more significantly, over the last 90 years, these 4 strips of land that make up this parcel, these 4 strips of land were conveyed in and out separately. After zoning regulations were adopted, and after your zoning regulations were amended, these strips of land were sold separately. So the predecessors in title never intended for this to be a building lot, and in fact, these lots are referred to as lots 41, 42, 43, and 44 on the Walker map. Do we have the Walker map handy? And I think this will be educational for the board. This one's better. So here is the map of Walker Manor, and we can hand this around, but basically what the board will see is here is Edgewater Place, and there were all of these lots, this is what I will call these rear lots, and there were 79 lots, and there were these strips of land, and each of these strips that we've been talking about provided these property owners with an opportunity to access the harbor. That was the point of this. But significantly, over the, I believe this was 1927, 24, and after that, the lots 41, 42, 43, and 44 were conveyed in and out. They were separately conveyed, the strips of land. They were never assembled until 1973. And George Wolfe was a lawyer in Bridgeport, and he was acting as a trustee. And at that point, there were conveyances that finally, in 1973, created these 4 strips of land into one parcel. But that was after the zone had already been adopted. And at that time, even though they were consolidated into a parcel, they didn't meet the classification. They did not meet the requirements for a building lot at that time. So this provision in your regulations that says that the present owner or his predecessors in title did not illegally create this non-conforming lot means that you cannot use this as a non-conforming building lot because it doesn't meet that standard. Because the history, and it's in the record, in the documents we submitted, these parcels were individually sold, bought, purchased, conveyed, and lot 42 was actually cut in half. So this never met the requirements of your zoning regulations for width or lot area, these 4 strips of land put together. So it was never a legally existing non-conforming building lot. And as you sit here today, you can look at your zoning regulations, you can look at the site plan, and when you apply the zoning regulations to this lot, to this parcel, it doesn't meet your zoning regulations. And that is simply the inquiry that this board has to make on this appeal. Now, another important point is technically, under your zoning regulations, the certificate of zoning compliance, the very certificate of zoning compliance that we are appealing, is required before you begin construction. And that didn't happen here. And that's 6.1.4, Certificate of Zoning Compliance. And it says, no non-conforming use, structure, or lot shall be constructed, reconstructed, enlarged, extended, altered, moved, changed, maintained, restored, or replaced until a certificate of zoning compliance has been issued by the zoning enforcement officer. That did not happen before the construction. And it's only now, only in April. So, my last comment will be this. The speaker who sat here said, we just want to enjoy our property no different than any other resident. Now, that speaker has the same issue at 104 Edgewater Place as 94. But the whole point of this appeal is that these property owners are asking to use a property different than any other resident, because any other resident has to follow your zoning regulations, and this does not comply with your zoning regulations. So we are asking you to uphold this appeal. What did I leave out? Anything else? Anything else? And I'm happy to answer questions.
Mr. Soto?
Attorney Green, so I've been building in this town for 40 years, and you always get a zoning permit when you apply to build something, and you get a certificate of zoning compliance when it's done. Stephen will come out, he'll check out your as-built, he'll walk the property, and then they issue, once all the departments, engineering and everything feeds back, and building department, then he issues this. So you're saying the certificate of zoning compliance is supposed to be issued before you build?
I can only...
I've never had that done. It's always on...
With respect to non-conforming lots.
Is that true, Stephen?
Article 6.
6.1.4. I have it. I can read it again.
It's quite common to issue certificates of zoning compliance in cases where lots are being merged together. But in this case, these lots are consolidated under section 643.
In 1973, that's what he stated.
I'll read from the regulations. Section 643, 6.4.3. Notwithstanding the provisions of 6.4.1 and 6.4.2, vacant non-conforming lots may be combined to reduce any nonconformity with respect to lot size in accordance with section 2.3.1 of the subdivision regulations. That regulation I just read has been used many, many times to consolidate non-conforming lots into larger building lots. And that's the case of this lot right now.
So
they use that regulation to take those 4 smaller lots and consolidate them into a larger building lot. This is a lot of record. This argument has been heard before, and the board rejected these exact same arguments back in April of 22 when they appealed the zoning permit.
Well, here's my response. First of all, 6.4.3 says, notwithstanding the provisions of 6.4.1 and 6.4.2, vacant non-conforming lots may be combined to reduce any non-conformity with respect to lot size in accordance with 2.3.1. These lots were not vacant. They had a dock, a shed, permanent structures on them. They were not vacant. They were being used They were being, as provided under the zoning regulations. Also,
Well, that's also in the record. Pictures, there was a patio with a stone wall around the lean-to. There was a lean-to with the roof on it. There was a built-in grill with the cement. They didn't, in the original hearing, they never mentioned, we argued that they weren't vacant lots. They never said a word regarding vacant lots.
and I have to add one more thing. I don't have the pleasure of coming to Milford that often. My office is in Bridgeport, and but it always bothers me when the regulations say one thing, and where I come from, you read the regulations and you follow the rules, and when someone says, well, this is how we do it, I can't, as a lawyer, I can't respond to that, because as far as I'm concerned, what is just, fair, and reasonable, and the way the rules run are as they are written in your zoning regulations. That is what governs the use of land in the town of Milford. So if there's something else going on, then the zoning regulation should be amended. But as far as I'm concerned, this is the law as expressed in your zoning regulations. This lot cannot, these 4 strips of land do not meet your zoning regulations as it's written in your zoning regulations. So this board cannot find that this complies. There are no facts. You have the complete record. You have the record of all the transactions that show how this came together. You have pictures ad nauseum as to how this property was used and that there were structures. And your regulations say that if you voluntarily created nonconformities, and even if you put together a nonconforming lot, but you've created basically this nonconforming lot, or your predecessors in title have created this nonconforming lot, you can't build on it. And if you have a nonconforming lot, but it's being used for an approved use under your zoning regulations, which this was, because prior to the amendment of your regulations in 1955, you had the right to use that property for docks, boathouses, and structures of that kind. This was, and then your regulations were adopted to create a special permit for those uses, and this was a legally existing non-conforming lot that had these structures on it. So there's no relief from 6.4.3. So this appeal should be upheld by this board. And I really appreciate your time. I appreciate the thought you've given this and the questions that you've asked, and your patience.
Madam Chair, may I make a quick reply?
Yes.
If I may, Madam Chair, this just procedurally, as Attorney Crusaden knows, this is a quasi-judicial proceeding, and it is a situation
So may I make a reply or not? I mean, you can rebut what I reply.
I haven't seen anyone recognized by the chair lately.
I'm sorry?
Okay.
Procedurally, I would suggest that this is not going to be a workshop where Attorney Crusaden has an opportunity to respond, and we have it on.
With all due respect, Attorney Green, you just had an additional response without being recognized. So you started, we're going to go one more response, and then we're going to end the hearing.
Well, so I will have another rebuttal?
Madam Chair.
You were the first to speak initially. At the beginning of this hearing, you were the first to speak. Then we heard from this side, then we heard from you again.
That is my point. That is not what the procedure is. It's presentation, response, rebuttal. And now we're going to go back to response and rebuttal, apparently.
I just have a brief point.
Hold on. Stephen?
He brought up some new points that were not previously brought up. I think Attorney Crusaden should get a chance to respond.
I am going to allow Attorney Crusaden to respond, and that will be that, and then we are going to close the hearing.
I just wanted to point out to the board that the issue of whether a certificate of zoning compliance is required prior to the construction There's been a judicial determination on that by Judge Frechette, who used to sit in Ansonia Milford Superior Court on a Milford case a couple of years ago. It was 17 Maddox Avenue that this board had also heard an appeal on. And Judge Frechette decided, and I've provided that case to Attorney Green previously, Judge Frechette decided that that certificate of zoning compliance pursuant to that exact same regulation cited can be supplied at the end of construction. It's not required to be supplied at the beginning of construction. I just wanted to point that out. Thank you.
Thank you.
And that case is distinguished.
Okay. We're gonna-
Distinguishable, I should say, I'm sorry.
We can't keep going back and forth. The board has no more questions, correct? Okay, this hearing is closed. Mr. Soto.
I move to uphold the decision of the zoning enforcement officer in accordance with the provisions of Section 9.2 regarding certificate of zoning compliance. Date certificate issued 4/19/24, Joel Green Esquire, for Christopher McKenna, appellant, CPK Properties LLC, owner of 94 Edgewater.
Second.
Okay, we have a motion to uphold the decision of the zoning enforcement officer and a second, open for discussion. Personally, I appreciate the passion of the appellants, and I understand that there are some interesting situations at play in this case. However, we have not heard any new arguments from the last time this issue was before our board. I believe the last time we were also called upon to look at a de novo appeal and think on our own, and we did at that time. So I appreciate that this is the next step in the process and that the appellant has the right to appeal yet again. However, the facts of the case, the premise that this is brought to us, that these are not zoning compliant lots, was already discussed and already decided by this board at our last opportunity to hear this issue. So while we are further along in the process and technically it may be a separate appeal, it is based on the same thing. Those are my thoughts. Anyone else? All right. Mr. King.
It would seem to me that when it came to getting the zoning compliance, that it met the regulations, and that Mr. Harris is right in doing so and issuing that certificate.
Okay, so we upheld the decision of the zoning enforcement officer in our last hearing because we evaluated the merits of the case and decided that it was zoning compliant. So we are being asked to do the same thing again. Let's take it to a vote.
I just want to say one thing. I mean, the last time the house was under construction, now it's been built, the zoning, it's been built to what they proposed, so, Stephen was right in issuing the certificate.
Right, it was built, yes, it was consistent with
It was
what
built as proposed.
Proposed, approved, and upheld by our board. Okay, ready for a vote.
The Superior Court situation that we're not even considering at this point, or is it the...
That's a separate appeal.
Okay.
My understanding is that's an appeal on our decision at the last time we heard from this property.
It sounds like there's no court order
Correct.
advising anyone to do anything.
Correct.
Again?
From what I heard from both counsel, there's an appeal of our decision from last year pending in the Superior Court, and that is still being litigated. So there's no court order in place. with respect to what, orders we would have to follow or any other agency or body would have to follow.
So we're not in a double dose situation here, or we are?
If, for example,
No, go ahead.
Please.
last year's decision is currently under review, if you will, by the Superior Court, and certainly either party has an opportunity with whatever decision comes out today to do the same thing with today's decision. It doesn't impact the prior.
Okay. Ready for a vote? We have a motion to uphold the decision of the zoning enforcement officer. Mr. King,
With the motion.
Mr. Wolf,
With the motion.
Mr. Soto,
With the motion.
Ms. Hirsch.
With the motion.
I'm with the motion. Motion passes. Mr. Dubois, can you please go get Mr. Montano? Thank you. Welcome back, Mr. Montano.
Next,
Yes, we are on to item number 4.
Carmen Roads.
That's the one.
110 Carmen Road South, MBP 38/533/1X, R 12.5, Phil Preto, I believe, owner, variance section 3.1.4.1, east side yard setback to 4.3, where 10 feet required to construct addition, surveyed by R Plane 1524.
Okay, please state your name and address for the record, and you can proceed with your presentation.
I'm sorry?
Please state your name and address for the record.
Yes, it's Phil Preto, 110 Carmen Road.
Okay, and go ahead with your presentation.
Thank you. I really don't have a very good reason for hardship.
Sir, can you speak more into the microphone, please? Thank you.
I can't say that I have a really, my hardship is basically we have 3 embryos. I have 3 children now, and there's another one that's going to be born in about 2 years. It's the girl. They were developed, so we believe that they should become viable human beings. So we did some house hunting and so forth, but we love the neighborhood. There's 40 some odd kids that are under the age of 5. So we would like to stay there, but it's really tight for what that is. So I wanted to put a 2-bay garage with an addition with a master bath and basically a master suite over the garage. And that's, I think, pretty much it in a nutshell.
Thank you. Any questions for the applicant? Okay, so, Mr. Soto, did you have something?
So you're going to put on a 30 by 24 garage, 30 wide, 24 deep?
It's the current width of the house, so that's what I was hoping to do.
Mr. Harris, what's the setback supposed to be on that? On that side?
10 feet.
10 feet, okay. So,
It's 10 feet, and he's asking for 4.3.
right. So you don't think you could cut that garage down any? 30 feet's pretty wide.
I'm sure I could. I was just hoping that I could.
Because in your own words, you don't have a hardship.
Yeah, I think that a bona fide hardship is something that I was told is something that's a lot greater than...
It goes with the land. In other words, you have an odd shape, something unique to the neighborhood.
Why is your lot particular, why would your lot create undue hardship for respecting zoning regulations? And what I see is that every house on Carmen Road is 12,500 square feet, 100 feet wide, 125 deep, where 80 wide and 100 deep are minimum. All the lots are zoning compliant, even wider than required, and everything is identical on that street. So we're looking for something about your property, about your land, that makes application of the zoning regulations a hardship.
I mean, an average two-car garage is 24 feet wide. That's the average.
Okay.
So,
That would be fantastic.
I mean, if you made it 25, okay, so,
24
okay,
feet
so you're 20,
wide.
okay, I read that wrong. It's 30 feet to the property line, it's 25 feet, 26 and a half feet wide, okay.
The addition
Gotcha,
is
yeah,
26 feet, yeah.
So, I mean, if you made it
What
24.
about a single-car garage rather than a two-car garage?
Well,
Single-car garage, Bill, would be how wide and...
Well, he could make, if he made it 20 feet wide, he wouldn't need a variance.
Correct. And that would be enough for one car with extra space.
Yeah. I mean, I'm okay with 24 feet, cut it down, and you have 6.5 feet there, almost 7 feet would be, he's only needs a 3-foot variance then.
Right, but a 20-foot wide addition still fits a one-car, the house has a one-car garage. 20-foot wide addition would retain a one-car garage and be a generous addition on the second floor of living space.
Yeah, that would make, he could even
And
make
that
it.
would be completely zoning
He
compliant.
could even go deeper into the backyard.
Right.
I was just hoping to have a 2-bay garage, that's all.
Okay. Any other questions for the applicant?
Are we saying here that you can't get a two-car garage with 20.8 feet?
It would be really tight.
It's tight.
You could do a single 16-foot door, but you'd be small cars. I mean, you get them in there, as long as you don't have 2 trucks.
Plus the addition upstairs at 20.8, it would be zoning compliant, and there would still be a 500 square foot, almost a 500 square foot addition on the first floor.
And to your point, Bill, it can go further back. You can create more square footage by going back. There's no rear yard setback issue right now. I think that there are ways to redo this that don't require any zoning variances.
Would possibly 22 feet be okay?
Well, that will be for us to discuss. Any questions for the applicants? Okay, is there anyone speaking in favor of this application? Is there anyone opposed to this application? Any more questions for the applicant? No. Okay, well, at that then, we're going to close this hearing, which means we are going to start discussing and we will render a decision. Okay? This hearing is closed.
Okay.
Mr. Soto, you want to make a motion?
Madam Chair, discussions have to be audible.
Okay.
Okay, we were discussing
Going 22 feet.
the motion.
Yeah.
I mean,
Let me make the motion for 22 and see what the board discusses.
okay.
Okay, I move to approve as presented with the following modifications: the garage to be 22 feet wide, the petition of Phil Petro, owner, vary section 3.1.4.1 east side setback to, so let's see, we would be adding 4.3, and we'd be taking off 2.5 feet to 6.8. Side yard setback to 6.8 where 10 feet required to construct addition. Surveyed by R Plane 1524. Anybody want to
Second.
Okay, we have a motion.
Okay, just so I'm hearing this right, the condition or the amended motion was to approve a 22-foot wide garage, which would push the setback to 8.3 feet where 10 is required.
No, I believe he said 6.8.
I said 6.8. Okay, did I do the math wrong?
Well, you said 4 feet. 22 feet wide takes 4 feet away from the garage.
No, it takes
which adds-
4.5 feet away. It was 26.5.
No, it's current, as presented, it's 4.3 feet. So if you take 4 feet off the garage, then you're adding 4 feet
Oh,
to
you're
the
right, I only
setback.
took 2.5 feet off. So it's 8.8 feet away.
Take what?
I took 2.5 feet off, you're right, I did the math.
We're taking 4.5
We're taking
off
4.5 off,
Yeah.
plus the 4.3, so we're 8.5. Let me reread that motion then. Okay. I move to approve as presented with the following modification. The garage will become 22 feet wide. The petition of Phil Petro, owner, vary section 3.1.4.1, east side yard setback to 8.5 feet, where 10 feet required to construct addition. Survey by R Plane 1524.
Second.
Okay, we have a motion and a second, open for discussion.
Well, by going 22 feet, he's got room for 2 cars, and he wants a 2-car garage. That's about the minimum you can go with a 2-car garage.
I appreciate that. However, the house as it stands has a 1-car garage. Most of the houses have 1-car garages. Every lot on that street is identical. There is no hardship here in the land. There is no hardship.
But you're really only looking for 1.5 feet. And there was nobody against it, so I don't have a problem with that.
Mr. King?
I agree with the chair. I don't see any hardship here. I don't think the foot makes a difference. This can be zoning compliant, and there are other options to expand it.
I think that there is a lot of room here to build an addition that gets the applicant the square footage in the living space that he's looking for with modifications. The house wasn't built with a 1-car garage. If it could fit 2 within zoning regulations, that would be one thing. But it can't. I think you can still get the square footage, the living space square footage desired. It will be a well oversized garage for plenty of storage. I just don't see it. Okay. Any other comments?
Madam Chair, to be honest with you, I'm a little confused. Right now, you have,
No. This is just, the hearing is closed.
Okay.
Just discussion amongst ourselves.
right now, there is a 1-car garage? I don't have plans.
The driveway comes in and the 1-car garage goes this way, I believe. Now he wants to come in this way. But you got to drive in this way. It's under the house. This is a full addition. Here this is the existing garage. This is the street you drive in. So this would be added on. This is the existing garage. Okay. Any other comments? Yep.
Also, with a single-door garage, I think it's possible to get 2 cars in there anyway. Average, regular car is about 5.5, 6 foot wide. SUV is probably 7.5 feet wide. So I think with a single-car garage, you might still be able to get 2 in there and still be zoning compliant.
So you could do a 20.5 foot wide and be zoning compliant based on these numbers we discussed tonight. Okay, well, let's take it to a vote then. Mr. King?
Against the motion.
Mr. Wolf?
I'm with the motion.
Mr. Soto?
With the motion.
Mr. Montano?
With the motion,
I'm against the motion. Motion fails. Okay, Mr. Montano, 89 Morningside Drive.
89 Morningside Drive, MVP 39/616/3, R 12.5. Scott Farquharson, I'm sorry, I butchered your name. Agent for Zion Protopopus and Bettini Thief, owners, variance section 4.1.4, front yard projection to 10.17, where 21 feet permitted to increase size of deck, surveyed by R. Wasmer for 3024.
Good evening. My name is Thomas Donovan. I live at 42 Thompson Hill Road. I'm representing Zion Propapus and Bina Thiel. I'm from Baybrook Remodelers, the contractor on the project. Our project is to construct a 4-foot by 15-foot deck, front deck extension. That property is in a R10 zone. We're requesting a variance of section 4.1.4 front yard projection to 10.17 feet, whereas where 21 feet is permitted to increase the size of the existing deck. This property has an existing non-conforming structure. Both the home and the existing deck are over the required setbacks. The house has a front yard setback of 10.42 feet, where 25 feet setback is required. The existing front yard deck is 14.17 setback, where the required is 21 feet. The proposed deck would end up having a setback of about the same as the existing house. Our hardships are that the unique shape of the lot with existing non-conforming structures, the homeowner looked at expanding the deck in the rear of the existing deck. It is not feasible to do because of the location of the electrical service for the home. Thank you for your consideration. Any questions?
Any questions for the applicant? Mr.
Can you repeat again what the hardship, your hardship is on, to extend the deck? And why can it be extended in on the back side of the deck instead?
No, it can't. The position of the house is the back side of the house. The deck is to the side front of the house. If you look up there, and the driveway comes around, and there's a access there to inside the house. I don't have my drawing with me. I should have brought it over here to my table. But does it not show that on your drawing there? The existing deck here, we want to come out here, that there.
Sir, I know it's difficult, but we are going to need you to speak into the microphone for the recording.
I'm sorry.
Thank you, Mr. Harris. So that's the existing deck, and the smaller portion on the right is the proposed addition, correct?
Yes, 4 foot out.
Okay, so now you've got wooden steps coming down from the existing deck, and you have concrete steps going into presumably the front door of the home?
Yes.
Okay, so I guess the question on the table, if I may, Mr. King, is why can't those wooden steps come down and that deck be extended closer to the front door rather than increasing the nonconformity further into the front yard setback?
I believe because of the unique...
Not at this time. I'll let you know.
So I believe that just because of the design of the nonconforming and the shape of that lot just makes it tighter to get in there.
What's the distance between the entrance door to the house and the beginning of the existing deck? What's that space?
I don't have that in front of me.
You got plenty of room to do what you want to do, Sarah. Yeah, there's
To
no
do
reason
the
to put...
extension on the
Yeah,
other
to put the
side.
4-foot extension on the rear of the deck, move those
Yep,
move those stairs
wooden
back
stairs.
towards the concrete, the bluestone walk, and you'd have the exact same deck you're trying to get.
I believe the homeowners are here, if they could comment on this.
Okay, the homeowners, sure.
I'm Zinon Pro, Pavas 89 Morningside. The issue to moving it backward is mainly the electrical panels. The electricity panel as it comes in is here. So
Is it on the existing deck, or is it behind the deck?
it's next to the deck. So extending it backward would require to either incorporate it into the deck, or I don't know if UI would even move it.
No, you don't have to move the meter. The meter's, what is it, 5 foot off the deck?
It's not just the meter, it's the solar panel, everything's coming in there. It's a big bulky area.
Yeah, but add the 4 feet and then build an enclosure around the meter and the solar switch.
May I also add that...
Ma'am, into the microphone, please.
And identify yourself.
These hearings are recorded, so everything needs to be into the microphone.
Right. My name is Bettina Thiel. I am also the homeowner. There is the electrical, but at the same time, there's also a height difference because this is on a hill. So where the deck ends now, the electrical is accessible from that little bluestone walkway. At that point, if we were to extend the deck further towards the front door, which we considered, the electrical would be like right at the height of the deck.
Okay, so don't run the deck all the way, keep the deck 4 feet off the house and then start your 4-foot extension. And by code, you only need 3 feet in front of it to work for safety for electrical.
I don't believe that was possible. I did suggest that.
I don't see why it can't be. Do you have a picture to show us what you have? I mean, any electrician's going to stand on the existing ground to work on that stuff. And the code says you need 3 feet in front of your electrical equipment. So all you have to do is jog the deck back 4.5 feet, and then you still get your extension. So instead of it being, what's the width there, 18 feet? 15 feet?
Proposed is 14, existing is 14, proposed is 18.
Right. And you could also add on to the end of the deck, too.
There's no room to keep 3 feet off the electrical.
I can't see that from this drawing. It looks like there's plenty of room. How much do you have from the steps to the existing house? The rear step of the deck, what's that space in there? From the step to the house, from the edge of the deck, how many feet are there? Does your builder know?
No, we don't have that to that detail.
Sir, into the microphone, please.
We don't have that detail to the design at this point. If we need to
Well, maybe you need to come back with pictures and measurements.
Okay.
Give us exact measurements of what the equipment, and give us a picture of what the equipment looks like.
Okay.
Take some outside pictures of existing
Yes.
conditions, of the deck
Right.
and everything.
All
And then we have more information to
We
decide
can
this.
certainly hold the hearing open so that we can hear more information next
Right.
month,
Yes.
and that might be beneficial to the applicants. I think the complication right now for the board is that, as you say, this house and the deck are already infringing on the setback. So we don't look to increase nonconformities, we look to decrease them. So
Right.
we think that there is other room to get you more square footage on this deck without increasing the infringement in the setbacks and the nonconformities. So we can keep the hearing open until next month for more information.
May I ask a question? If we keep it in the current footprint, do we still need to get a zoning variance?
If you make no change to it as existing?
Well, if we replace the existing deck with, in the same footprint.
No, I don't think so, right?
Just rebuild it, new materials?
Yeah.
Same footprint?
Yeah.
Madam Chair, yeah, an existing nonconformity may be replaced in kind. So you can take down the existing non-conforming deck and reconstruct it to the same size in the same location.
Thank you.
Is that what you would like to do?
Let's discuss it, but thank you.
Okay,
for the
so we'll hold this application open until next month, hold the hearing open?
Yes, I'd appreciate that.
Okay, okay, great.
Thank you.
Thank you.
Thank you.
All right, so that hearing will stay open until next month. And, yes, Mr. Montano, on to the last one.
Number 11, Edidor Parkway, MBP 56/506/A24, R12.5, John Grant, owner, bearing section 3.1.4.1 front yard setback to 21 feet, .8, where 30 required to construct attached garage with living space above. Surveyed by our plane 42624.
Good evening.
Good evening. My name is John Grant. I live at 11 Edidor Park. And as you read, I'm seeking a variance for 21.8 feet from my property line where 30 is required. My hardship is my front, I'm on a corner lot. I have 2 front yards. The street that the garage would be facing is not straight. It has a curve to it. And the closest spot from the curve to the corner of the proposed structure would be 21.8 feet. As the structure goes towards the house, the distance actually increases from the property line because of the curve. And the other portion, the other hardship is my existing house is non-conforming also. It is not 30 feet away from the property line. So by doing the addition on the back of the house to attach the garage, it basically pushes that garage face a little bit more towards the road than what if I had been able to set it all the way back.
Okay, so,
Excuse me, just one thing. I'm sorry, I have a hearing disability, so please, if I ask you to repeat something, please don't take offense.
sure, no problem. Thank you for letting us know. So what is the implication if you were to just move that garage back and make it 30 feet off of the property line?
If I push the garage face back, it would push it past the addition to attach it to the house doesn't need to be, would have to increase in the depth in order to keep the back line straight so that the attachment would go to the stairway that would go up onto the second floor. So instead of only going 9 feet back of the house, if I push the garage back another 8 feet or 7 and some odd feet, then that addition in the back, instead of being only 9 feet, increases to like 16 feet, which is something that I don't need. I only need enough room to do an addition on the back of the house to get the garage attached.
Mm-hmm. Mr. Soda, is there any reason that the stairs up from the mudroom have to hit at that back corner, or can the whole garage come back and the stairs, the mudroom hit somewhere in the middle of that sidewall?
The number's kind of small. What's the depth of the garage? 26 feet?
Yes.
I'm sorry? The garage depth is 26 feet? Depth.
Yes, that answers yes, it is.
Well, he's probably putting him in the back there so he has more room for the cars, but he could put the stairs into the mudroom and they wouldn't protrude into the garage at all, and then he could slide that garage back.
Slide it back, and then the mudroom would attach somewhere in the middle.
In the middle, 9 feet back, so, but if he put the stairs up into the mudroom and not protrude into the garage, you'd have plenty of room.
Mm-hmm. And
But
it's a very large lot for the zone. 19,000 square feet, we're 12,500 minimum.
If we step this garage back, though, and you had a vehicle in there, you'd be interfering with the stairs, because he's going to have stairs coming in that back corner, right?
Right. But I'm saying put the stairs into the mudroom like this.
Not in the garage, but in the mudroom.
Put them in here,
Okay.
so they don't protrude into the
They don't
garage.
take up garage space at all. It's just a door.
So they could be anywhere on this wall, you still close your door and walk right up. And then the door would be at the top of the stairs here.
And we're proposing how far back? To eliminate
To
the,
eliminate this altogether, 8.5 feet.
so, yeah, say we're moving that 50%, so those stairs are going to be dead center of that garage.
But to
You know,
Mr.
you're opening
Soda's,
up you're opening up your driver's door into a stair.
Well, no,
no, the stairs would be in the
the stairs
mudroom.
would be inside the mudroom
They
here.
would-
So no stair, it's not like they would come like this.
It would just be a door in the garage.
You just go up the stairs and then open the door, swing the
Okay,
door open.
no, I got you. Okay,
So it'd be
I'm
no
okay.
different than the whole thing.
understood.
Sir, are you understanding what we're suggesting?
I believe so, but to push the stairs into the mudroom, then, or actually would, they're actually in the mud, they actually come off of the mudroom. They're in the back of the garage. So I'm not sure what you're talking about pushing them into the mudroom.
Well, the stairs would start at the edge of the garage and go into the mudroom, and then the door would be, how many risers do you have?
Do you have are you sketching it?
Yes.
May I look at it?
Yeah, come on up.
Is the mudroom a single-story addition or a two-story addition? That's what, okay, single-story. Yep.
Okay, so. Okay. In other words,
I provided a floor plan. Do you have it?
Yes.
I don't, okay, so where's the floor plan? So this is the garage here?
Yeah, this is the garage. This is
Okay, so you were putting a landing in here.
correct.
This is the garage here?
This would be the mudroom.
Okay, that, yeah. Okay, so you're coming up here. Yeah, it wouldn't work.
Wouldn't work.
Not with what he's got on the floor plan.
Okay, let me see that floor plan again, please.
No, it wouldn't work.
Okay.
I'm going by this.
Yeah, I can see.
Yeah.
Okay. No, I'm going to take that. Thank you. Any other questions at this moment for the applicant? Mr. Montano.
You want a sewer or a septic? Sewer or septic, sir?
I'm sorry?
Are you on a sewer or septic?
Sewer.
Thank you.
Okay, is there anyone speaking in favor of this application? Yes, sir, if you could please use the microphone over here. State your name and address for the record.
Mark Payne. I live at 17 Edidor Park, the abutting neighbor to John's property. And I'm here to support the request made by my neighbors, John and Janice Grant. I've lived at 17 Edidor Park for 30 years, during which time the Grants have been great neighbors as well as part of a strong and stable neighborhood. During this period, multiple properties have been added on to and improved, and this proposal is consistent with and complementary to that. I realize zoning is necessary to protect the interests of Milford and its neighborhoods. In this instance, it's an impediment to improvement. The variance is required due to the radius condition of the road and the fact that we were a subdivision from World War I before there was zoning. All of our lots are non-conforming. We're faced with a lot of difficult issues due to the zoning. And in this instance, granting creates no hazard, it creates no impediment, there's no inconvenience in any circumstance. The variance would, however, have many positive impacts. It would enhance another property on our block. It would increase our property values and the grant list. And most of all, it would have a substantial quality of life effect for the grants. They are longtime Milford residents who have helped this city thrive, like many others. And granting the appeal makes sense in my world. And I would much rather look at this from my backyard and out my window than some of the, I appreciate the suggestions that you've made to help my neighbor do what he wants to do. But in this instance, I really believe that the proposal as presented is really the best fit for the neighborhood. I thank you for your time.
Thank you so much.
Do you have any questions?
Not at this time. Thank you.
Thank you.
And I have to ask if there's anyone opposed to this application. No. Okay, any more questions for the applicant? Okay, well then this hearing is closed.
I move to approve as presented the petition of John Grant, owner, vary section 3.1.4.1, front yard setback to 21.8 feet, where 30 feet required, to construct attached garage with living space above, survey by R. Plane 42624.
Second.
Motion to approve and a second. Okay. So the addition is 24 wide by 26 deep, with the stairs running through the back of the addition, which makes the garage portion really only, I believe, 18.2 deep. So it's pretty standard, pretty tight for a two-car garage. Correct, Bill? No frills here with this
Yeah, no,
garage.
he's got minimum space there.
It's a very large lot. There should be room to do this without a zoning variance. However, the house exists where the house exists. And it does leave very little option to attach it. And
Yeah, once I saw the floor plan, you can't do what he wants to do by sliding that garage back. It just won't work.
no,
And, it is a curve, and it is
it is on the curve.
It is a
yeah.
unique piece of property, so, unique shape, so I don't have a problem with this.
Yeah.
The front yard setback is better than the original house too as well.
Yes, so this garage is attached, which makes it part of the structure. It's not detached, it's not an auxiliary structure, and it is much further off the road than the existing house, that is true. So we're certainly decreasing something there. Okay, any other thoughts? Okay, on to a vote. Mr. King,
With the motion.
Mr. Wolf,
With the motion?
Mr. Soto,
With the motion.
Mr. Montano.
With the motion.
I'm with the motion. The motion passes.
Thank you very much.
Thank you. Have a great evening. Okay. So, new business. Let's see, we've got possibly Morningside Drive coming back next month. Any other applications? Or I guess that's for later.
Not that I know of, no.
No? Nothing yet?
Not that I know of.
Even knows of, sometimes I know things.
Okay.
Gulf Street coming back?
August. Gulf Street's coming back in August.
Right.
Okay, so some of you on the board may remember a few years ago when Attorney Burcham came to us after one of our meetings and just kind of ran through some procedure and some highlights for conducting our business well and efficiently. And he has agreed to come back next month's meeting. So he'll be here. Yeah, so he'll be here for the benefit of our newer members to give us a little primer in how best to continue doing our jobs. So that'll be next month. He and I had discussed doing it afterwards, but we might do it before at 6:30 if that's agreeable to him. So I will certainly let everyone know when that gets settled, just to keep him from having to sit through the whole meeting unnecessarily. So I'll certainly let you know with enough notice that you can make arrangements to be here a little early. Okay? Yeah, probably. That might be better than with everyone streaming in. Okay, any staff updates?
No.
How's your knee?
Doing very well.
Doing well. And Mr. Harris just had a birthday, so happy birthday, Mr. Harris.
Happy birthday, Mr. Harris.
Thank you, Ace, I'm still alive.
66, Stephen? Yeah, you're a year older than me, I know it.
Okay, motion to approve the minutes from last month.
So moved.
So moved.
Okay. And right now, we just have Morningside Drive coming in for next month. And
I've got a couple of more that have just come
trickled in?
Yeah.
Okay.
At least 2 or 3.
At least 2 or 3 more for next month. Okay, great. Well, it'll be a good July. With that, motion to adjourn the meeting.
Second.
Meeting adjourned.